This is the fifth part of my lecture on the topic of interpretation of Section 6 of the Hindu Succession Act 1956. In the last part, we discussed the substituted provision of Section 6, and we have seen the subsection 5 of that substituted section 6, which saves the partition which have been effected before 20 December 2004. So regarding this date, there is a further explanation is as the conferment of coparcenary status on daughters will not affect any partition that may have occurred before 20 December 2004. 20 December 2004 is the date when the bill for this amendment in the Act was tabled before the Rajya Sabha of the Parliament. Therefore, it is presumed that on the said date itself, 20 December 2004, general public came to know about the amendment. Hence, the conferment of the right on the daughter did not disturb the rights which got crystallized by partition before 20 December 2004. So, suppose there had been partition in the joint Hindu family and which took place before the 20 December 2004 and which is valid as per the prevailing law, then such a earlier partition will not be affected by the substituted provision of Section 6, which confers equal coparcenary rights on the daughter. But why this provision is made in subsection 5 of substituted Section 6? We have to see it. The proviso clause to subsection 1 to section 6 and subsection 5 of this substituted section 6 saves any partition which was effected before 20 December 2004. However, explanation clause to section 6 subsection 5 recognizes only such partitions which were effected either by execution of partition deed duly registered under the Registration Act or by a decree of a court. Other forms of partition have not been recognized under the definition of partition in the explanation. Why? The intention behind inserting such a provision was to avoid any sham or bogus transaction, which could be made in order to defeat the rights of co-partner conferred upon daughters by the Amendment Act 2005. The intent of amended section 6 is to ensure that daughters are not deprived of their rights by male co-partner, thereby setting up of any previous defense of any previous oral partition or by of any unregistered memorandum of such oral partition. So supposing after the amendment came into force, a daughter can claim a partition against her brother. She may file a suit in the court for that purpose. In that suit, the brother may take defense that we had already partition, so she cannot again ask for the partition. We had earlier oral partition, so she cannot ask for the partition. So the intention of this legislative enactment is that such brothers co-partner must not take such a defense of oral partition so as to deprive their sisters from participating in coparcenary rights. Because such recorded memorandum of oral partition, which is unregistered and without having support of any contemporaneous public document, can be manufactured at any point of time. Means for the purpose of taking defense, such brother co-partners can manufacture any such evidence regarding their so-called oral partition. Therefore, the subsection 5 of section 6 carries an explanation clause which says that partition means only that partition which has been registered under the Registration Act or which has been effected by the decree of the court. Then for the purpose of claiming coparcenary rights by a daughter against other co-partners of the family, it is essential that first coparcenary should exist and coparcenary property should exist. Then only daughter can claim partition. So regarding this issue, we have to again recollect the provisions of earlier section 6. Before the amendment. Explanation clause 1 to earlier section 6 of the Act provides a mechanism under which undivided interest of a deceased co-partner can be ascertained. It means for the purpose of finding out undivided interest of deceased co-partner, a notional partition have to be assumed immediately before his death, and the same shall devolve upon his heirs by succession. The fiction of notional partition was meant for an aforesaid specific purpose of ascertainment of undivided interest of co-partner. Such a notional partition was not to bring about the real partition. Notional partition means not real partition. It did not affect the severance of interest of other surviving co-partners or of other such family members who are entitled to share upon actual partition. Thus the legal fiction of notional partition is only for the purpose it serves and it cannot be extended beyond. And what is the purpose? Ascertainment of the undivided share of deceased co-partner. Therefore, even if deceased co-partner had left behind female heir of class 1 or male heir claiming such female heir, there is no disruption of coparcenary by statutory fiction of partition. There is no description of coparcenary merely because of such a notional partition. Fiction is only for ascertaining the shares of deceased co-partner, which will be allotted to his heirs as and when actual partition takes place. The dim fiction of partition is for that limited purpose. Hence, the substituted new section 6 presupposes the existence of coparcenary, wherein there is an enlargement of daughter's right. There was a confusion that because of the operation of earlier section 6, when we have to ascertain the undivided share, quantum of undivided share of deceased co-partner, we have to cause a notional partition, but many wrongly understood that partition as real partition, and after the amended provision came into force, when the daughters are claiming their share, other co-partners were taking defense that we had already partitioned by operation of proviso clause of earlier section 6. But it is wrong contention. By operation of earlier section 6, there is merely a notional partition but not the real partition. Therefore, even if there is a death of any co-partner before the amendment of 2005, then for the purpose of ascertaining his undivided share, there is a notional partition, and merely because there is a notional partition, there is no disruption of coparcenary. No disruption of coparcenary means coparcenary still exists. And when the coparcenary still exists on the date of commencement of the Amendment Act of 2005, then daughters can claim partition in that coparcenary property. This point is further clear. In one case, in one judgment of the Supreme Court, in the case of Man Singh versus Ramkala, which is reported in All India Reporter, year 2011, Supreme Court, page 1542. So in this case, the question of devolution of interest in coparcenary property arose on the death of male Hindu who left behind wife, son and 3 daughters. The facts of this case is relating to that area which is before the Amendment Act of 2005. It was observed that until the disruption of coparcenary by actual partition, the definite share cannot be claimed with certainty. The question in said case is, when the partition has not taken place, actual partition has not taken place, whether the statutory fiction of notional partition, which was contained in the proviso to earlier section 6 with respect to determination of shares of deceased co-partner and its devolution thereunder, will disrupt the coparcenary. What was the question in that case? Whether that statutory fiction of notional partition, which were contained in the proviso clause to that earlier section 6, whether it will disrupt the coparcenary. The Supreme Court gave its finding in negative. So Supreme Court said that it will not disrupt the coparcenary, even though there is a death of any male co-partner before the Amendment Act of 2005, and when when there was not any actual partition. That means on the date of commencement of the Amendment Act, that is on 9 September 2005, there exist the coparcenary and coparcenary property. So daughter can claim partition in that coparcenary property, and she will have same and equal right to that of son of the coparcener.